Hello. Are you an employer or an employee who thinks that the employment laws are crazy confusing and you just wish someone could simplify them for you? Well, you come to the right place. My name is Jack Malley. I've been practicing law for 30 years. I'm a labor and employment lawyer and a litigator. I practice in New York and Connecticut for a firm called Smith, Buss & Jacobs. And you folks out there who think that the employment laws are confusing are absolutely right. They're crazy confusing. And there's at least 4 reasons why. Number one, there's a load of them. There's tons of employment laws. You can't even keep track of them. Number 2, they come from all different sources, which is basically government sources. They come from the federal government, come from the state government, the county government, the city government, other local governments. Third is, because of all these different laws coming from all these different parts of the government, the laws overlap. So for example, there's federal, state, and local discrimination laws. They're mostly the same, but some parts are different, and that gets really confusing when they're different to tell which law applies to your situation. And finally, and this is probably the most important reason why it's confusing, is that there's always new laws. They're constantly coming, especially the last few years. A typical situation is one state passes a law on a hot topic, then there's a copycat effect, and maybe every other state or most states do the same exact thing. So folks, because of all this confusion out there, what we decided to do here is present a series of videos about various employment law topics. We're going to keep it basic, fundamental, essential stuff, so you'll have the basic stuff down and be able to get into any kind of conversation about these topics with confidence. We're not going to get down into the weeds. We're not going to get down to specifics that are way down there at the bottom of the list. That would take hours and hours. Because of that, you should understand that this is not legal advice I'm giving you here right now. Situations that you might have out there are very fact-specific. You would need to take that to your own lawyer to discuss what your situation is. But what I'm telling you right now should not be taken as advice, just information. So let me start off by saying the very first topic that we're going to cover, this is episode 1. Topic number 1 is this thing called reasonable accommodations. Most of you have probably heard of it out there. It's a bit of a tough topic to start out with, but we're going to do our best. It also can be a little bit confusing. So what I'm going to do is just get into some general information about this and then get into a little bit more detail for you. So this thing called a reasonable accommodation refers to laws concerning employees who have a disability and whether or not, in essence, the employer can figure out a way that they can still do their job with their disability. The first law on disabilities, and the first well-known law on disabilities and reasonable accommodations, was a law called the Americans with Disabilities Act, which was enacted in 1990, a long time ago. What happened was, kind of like what I was telling you before, after that, the states all followed suit, most of all the states, and followed their own laws on disability and on reasonable accommodations. So as I proceed here today with what I'm talking about, what I'm going to talk about is general concepts that apply to all these laws, federal and state, but in certain situations where there's distinction in the states that I practice in, which is New York and Connecticut, I'll give you a little side note on some New York or Connecticut law that might be different from the general concepts out there. So where do we start? First thing is, who is protected by these laws? Well, the people that are protected are employees and prospective employees. So if there's a person who's working, who's already employed for an employer and has a disability, the law applies to them. If there's a person who's applying for a job, the law also applies to those folks. So that's who it applies to. Next question is, how does the whole thing get started? How does this process, this thing called reasonable accommodation, get started? And as I said, this concerns a disability an employee might have. So the way it gets started normally, the usual way is, the employee comes to the employer and says, Mr. Employer, I have this situation. I have a disability now. This just happened to me. And I'd like to work out a way that I can still work for your company with my disability. That's the usual way. The other way it happens is, and this provides a requirement, an obligation of the employer, is the employer notices a new disability and is obligated to ask the employee about it for the purposes of finding an accommodation, even if the employee doesn't bring it to the attention of the employer. For example, let's say there's an employee working for a company for about 10 years, and all of a sudden, Monday morning, this employee rolls into the office in a wheelchair. So this is something that the employer would, of course, would notice and would then, by law, have to ask the employee about this disability, this new disability, and they would then have to figure out if an accommodation can be provided. And we'll talk about that, what an accommodation is, in a little more detail. Right now, in fact, I'll talk about that. So what is a reasonable accommodation? What is this thing that employers have to try to work out with the employee? Accommodation, you probably heard that word in other contexts. That's basically like an agreement between two people. In this case, an agreement between an employer and an employee, where the employer says, hey, we see you have a disability. We're going to adjust the way you work for our company to allow you to work here with your disability. That's an accommodation. So what about the word reasonable in front of that? What that really refers to is it reasonable? Should the employer have to do this? Is it reasonable that the employer has to provide this accommodation? And employers don't have to provide accommodations in all instances. And they don't have to provide an accommodation that the employee requests. They can offer something in the alternative. I'll talk a little bit later, I'll talk about when employers can say, no, we're not going to do this. But the point is, if it's unreasonable, they don't got to do it. So the next question is, what happens next? How does this process get going? And there's a term that's used in the disability law called interactive process. And what that is, it's basically a conversation between the employer and the employee. How can we work this thing out? How can Mr. Employee or Mrs. Employee get an opportunity to still work at this job even though he or she has a disability? So this conversation can take place verbally, or it can take place by email in writing. But the point is, by law, the employer and the employee have to engage in this conversation to see if an accommodation can be provided for the employee. And what do they have to do in this interactive process? There's a couple of things. One is, both sides have to act in good faith. That's the law. What does that mean? It means they got to try hard. They got to try to work this thing out. They can't just turn a blind eye to it. They got to do it in good faith. The next thing is, that's a very significant thing in the law of reasonable accommodation, is if the employer asks for medical documentation from the employee's got to do it. They're obligated to provide that. So the next thing that's really important is, it has to do with really who has a better shot in a lawsuit, is this thing called breakdown of the interactive process. As I said, both sides have to engage in the interactive process. But if one side or the other breaks it down and has no good reason for it, essentially they're going to be in a bad spot in a lawsuit. So let me give you a couple of examples of where it could break down and whose fault it would be. Let's say the employer asks the employee for some medical documentation and the employee doesn't do it. And then the employee goes and sues the employer for not getting an accommodation that he or she wanted. That employee would lose because the employee was responsible for the breakdown of the interactive process because the employee didn't provide the documentation. On the other side of the coin, let's say there's a conversation going and the employee suggests, hey, how about this? How about you give me a larger size computer so I can see better, something like that. And the employer says, no, we don't want to do that. But we're going to go research some other possible alternatives for you and come back to you with other offers. and the employer doesn't do that. The employer doesn't live up to his or her word and come back with those options, and then the employee doesn't get the accommodation and sues the employer's in a bad spot. They broke down the interactive process. They promised to provide alternatives and they didn't do it. So they'd probably be liable in a lawsuit. So that's how the interactive process works. Next thing I want to talk about is what are the defenses the employer has? Or basically, what are the reasons that are viable reasons that an employer can give for denying an accommodation? And there's basically two what we call defenses, or two valid reasons that an employer can say, no, we can't do this. One is this thing called an undue hardship. And what that really means is there's two possibilities there. One is it's just too expensive. And what comes into play there is how big is the company, how much money do they have, that kind of thing. And the other one is if the request would like fundamentally change the way this employer is doing business or their personnel or things like that. So those are the two kind of situations. So I'm going to give you a couple of examples of what would not be an undue hardship and what would be an undue hardship. Let's say we have an example of a bookkeeper, right, who works for a big company like IBM, right? And this bookkeeper has been working for the company for 10 years, but then develops some problems with her eyesight. She can't see as well. So she comes to the employer, she goes to IBM and says, on my regular size computer, I can't see the data that I need to do my work. Can you give me a computer that's twice the size so I can see that stuff? It'd be a lot larger and then I can see it and I can do my job. There's no way in the world this would not be a reasonable accommodation that IBM would have to give, because it doesn't cost anything for IBM and it's no big deal. It's just a bigger screen on the employee's desk. So IBM could not claim undue hardship in that circumstance, no way. Another example is, let's say it's the same bookkeeper. She's driving in her car, she gets into a really bad accident, and she has a horrible back problem. So she can't sit down for any long period of time. For example, she can't sit in her car for more than 5 minutes, and she has a 45-minute drive to work every day. So she goes to the employer and says, I got this back problem from this accident. I can't sit down for more than 5 minutes in my car. I can't drive to work. How about this? How about I work remotely? And then while I'm working from home, I can get up every few minutes and stretch out my back and I'd be okay. And I can still do my work because the IBM network will get me there. And by the way, other people work remotely in this company, so this seems like this would be a fair accommodation. And yes, that would be. There's no way IBM could argue in this situation this would be unreasonable. They couldn't argue this is an undue hardship on the company. If this was denied and the bookkeeper sued IBM, the bookkeeper would win. But what's some examples of where a company would have an undue hardship? So one example is a situation where you have a construction worker. Let's say it's a construction company, and there's a gentleman who worked for the company for about 10 years. Then he gets into there's a lot of car accidents out there. So he gets into a car accident and he has a very serious injury, his knee, a very serious knee injury. The result of the injury is he can't stand up for more than 5 minutes at a time. So if you're a construction worker, you stand up all day. There's no way that you can do the job if you can only stand up 5 minutes at a time. So the employee comes to the employer, the construction company, and says, hey, I got an idea for accommodation. Before I worked for you guys, I was a salesperson, and I know all about the construction business from working with you all for the past 10 years. How about you give me a job as a salesman for the company? And that could be, in some situations, a good offer of accommodation. But in this company, they only employ one salesman. They already have one guy who does that. So in order for the employer to grant the accommodation, they'd have to fire the other guy. And that is definitely an undue hardship on the company. The law is that an accommodation can't require the displacement of other employees. So in that case, that construction company would be on good grounds to say, hey, you're in a tough spot, we realize that, but we can't grant you that accommodation. We can't fire this guy so you can have that job. Another example is a situation of a baked goods company. A baked goods company that operates in the Northeast. There's a salesman who works for the company. As part of his job, he has to go to the northeastern states to visit the customers. He drives to Connecticut, he drives to Rhode Island, he drives to Massachusetts, he drives to Vermont, etc., and he meets with customers. That's what his job is. Another car accident. He gets into a bad car accident, a really serious car accident, and he's actually paralyzed. His legs are paralyzed, and his hands and arms are partially paralyzed. And it's a terrible situation. This gentleman comes to the company and said, I've been trying to think of an accommodation. This is what I got. How about you buy me this specially designed car for handicapped people that can allow people to drive even if they have the problems that I have. The company listens and does some research and finds out it would cost $100,000 to purchase that kind of car. And this company is a small company. Their total revenue per year is $500,000. So as bad as the company might feel about the bad spot that this employee is in, it's just not financially viable for that company to give that accommodation. They probably have to lay off other people and all sorts of other things. So in that case, this baked goods company would be on good grounds to say, we feel horrible, but that's an undue hardship on the company. We can't give it to you. So that's some situations of undue hardship. There's another good argument that an employer could make to deny an accommodation, and that's what is known as the direct impact or safety argument or safety defense. What that basically says is it's an argument by the employer. If we give the employee the accommodation, it's going to put other employees at risk or other people at risk, physical harm perhaps, on the company grounds if we allow for this accommodation. So let me give you an example. Let's say we have, again, a construction company and there's a crane operator. And there's an employee who's been operating a crane for the company for like 10 years. And then he develops narcolepsy, which is, you may or not be familiar with that, is where people can't control themselves from falling asleep. They fall asleep uncontrollably, and there's actually no cure for narcolepsy. So there's already been 2 incidents where this crane operator fell asleep while operating the crane, and huge, large, heavy objects fell from the crane down, and in those 2 instances just barely missed people and probably would have killed them if these heavy objects landed on these folks. So the crane operator, who's been a good employee for most of those years, is really, of course, upset about this, but comes to the employer and says, how about this as an accommodation? I've been prescribed some medication from my doctor that says if I take this, it's really going to help me with my narcolepsy. The employer does a little research with their doctor and they find out this thing could help, this medication could help, but there's no guarantee whatsoever that it would, in all instances, stop the crane operator from falling asleep on the job. So in that case, the employer is on good grounds to deny the accommodation because of the very serious risk of physical harm to somebody on the construction site if the crane operator fell asleep and dropped a heavy object again. So that kind of explains, I think, the whole sequence of things where there's an opportunity for a discussion and the kind of arguments that an employer can make in defense. There's a couple of other items I want to talk about. One is there's this concept called retaliation. Retaliation is a concept that's all throughout the employment law. But what it believes in this what it means in this context is, if a employee comes to an employer and says, I just incurred a disability, I want to get an accommodation, if the employer then basically takes adverse action against the employer, takes adverse action against the employee for even asking for an accommodation, such things as cutting the person's hours, changing the work environment, having them come different days of the week, or changing their responsibilities, diminishing their responsibilities on the job. all those things would be considered retaliation, and that's not allowed under basically all levels of employment law, federal, state, etc. The employer can't punish the employee for asking for an accommodation. And the last thing I want to talk about is basically what would happen if there was a lawsuit. Of course, this is a really detailed topic, but the main point to be made here is if an employee has a claim that the employer did not properly or legally engage in a interactive process or did not give an accommodation that the employee thinks is reasonable, and if that's a good claim, the employee could bring a lawsuit, and what the employee could do is recover damages. There's two types of damages. One, the employee could recover lost income. For example, if the employee was denied an accommodation and he or she could no longer work for the company, the employee would be out of work. And if the employee had a good claim against the employer, he or she could recover the income lost. And the second and last kind of damages that you see in cases regarding reasonable accommodations is that the employee, in extreme cases, this is not in most cases, in extreme cases could recover damages for emotional distress. And you can see why someone could go through a lot of emotional distress because they lost their job, because they incurred a disability. So that's the kind of thing that could happen in a lawsuit. That's a really short part of it. Of course, lawsuits go on for years and they're really complicated. We don't have time to talk about that here. This is everything I got for you today. This is the end of episode 1. We'll be back with episode 2 in about a month. If anybody has any questions about the information that I gave to you today, please feel free to contact us. My contact information is in the information box below. Thanks a lot.